Petition for Redress of Grievance to the House of Representatives, convening January 8, 2008, General Assembly, Statewide Session, Legislature, State of South Carolina. Mr. Speaker, my grievance. I am disturbed and perceive the state of South Carolina has created a method for the enrichment of for-profit companies through capturing of assessment fees, the funds paid to a nonprofit public benefit incorporated homeowners association by its members, allowing for the exploitation of people such as widow women, those mentally incapable of managing their financial property affairs, those receiving government-funded public assistance, and disabled pensioners. With the House of Representatives noticing citizens enact 384 of the 110th session, the South Carolina Nonprofit Corporation Act of 1994, requires the concept that membership in public benefit and religious corporations are not securities, thus resulted in some loss of protection under provisions of the Williams Act and our Takeover Bid Disclosure Acts, which call for notification by publication of the intent through purchasing 5% or more of the shares of a target corporation to install new management. And membership in public benefit and religious corporations do not represent a valuable asset or personal to each member and should not be sold for value, contrary to where home ownership by many, if not most people, is considered their most valuable asset. And members of a public benefit corporation cannot receive anything of economic value as a result of a derivative suit, resulting in reluctance to seek civil remedies when management fails to execute actions approved by the members because the possibility exists the pursuit would be fruitless, resulting in additional economic loss or disparity, creating an inequity which the type of people mentioned in the first paragraph above are basically left with a feeling of powerlessness, being unable to afford expensive litigation to defend their rights. Redress. The House of Representatives introduce a bill or bills for deliberation to possibly enact revision of both the South Carolina Nonprofit Corporation Act of 1994 and or the Horizontal Property Act, to not allow the incorporation of property regimes, homeowners associations, as public benefit corporations, where the transfer of property by deed results in a transfer of voting power, share ownership, to adopt optional Section 8.13 of the Revised Model Nonprofit Corporation Act 1987 so that no more than 49% of the individuals serving on the board of any public benefit corporation may be financially interested persons, as the writers of the Model Act had the knowledge and foresight to recognize the possibility of abuse. To not allow the formation of homeowner associations where more than 49% are not individual owner-occupied residences. And the state, through its attorney, conduct a thorough investigation of suspect public benefit corporations' activities of operating improperly and with impunity in the nonprofit form outside the scope of the intent of its charter granted by the state, along with possible matters of exceeding authority, ultra vires, obfuscation of share ownership records, and questionable by what authority for actions, quo warranto. And the state reimbursed me the sum of $51. $1 for countless hours of time investigating and researching on behalf of possible affected citizens. Minuscule because it involves the spirit of charitable organizations with an eleemosynary purpose in the public interest of the people of the state. $50 for the cost of copying and printing documents and records, which, after analyzing, cause my belief a grievance exists which is both egregious and outrageous. Respectfully submitted, Jack Taylor, 215 Duncan Chapel Road, Apartment 5, Greenville, South Carolina.